I'm Andrew Flushy, your Virginia Traffic and Misdemeanor Defense Attorney. If you're charged with driving on a suspended license, fourth offense in Virginia, you need to be aware that you're at a risk of actual jail time. As you may know by now, driving on suspended third offense in Virginia carries the mandatory minimum jail time of 10 days in jail if you're found guilty. Well, what does that mean if you're charged with a fourth offense? Well, unfortunately, it means that you're still looking at 10 days of mandatory jail. However, you could get more than that. For a driving on suspended offense in Virginia, it's a Class 1 misdemeanor, which means the maximum punishment is 12 months in jail. Now, a fourth offense, unless there's some crazy aggravating factor, I can't imagine getting that much jail time. However, a lot of judges do consider that if you've had a third and you went to jail for 10 days and now you're driving again, they feel like they need to up the ante a little more and give you more jail time. So on a fourth offense, driving on suspended, some judges will consider giving you perhaps 20 days of jail. So that's what I would typically counsel the client, is that that's kind of what you may be looking at, is maybe 10 to 20 days if you're found guilty. It definitely depends upon the specific court where your case is pending though. So it definitely differs based on all different courts around the Commonwealth. Well, what kind of defenses might you have for driving on suspended fourth offense? One of the best defenses is, did the officer have a good reason to pull you over? If he didn't have a good reason to stop you, then all of the evidence and information he obtained throughout the stop doesn't come into court, and typically that would mean that you win. Another good defense on a driving on suspended fourth offense would be if the officer can't prove that you knew you were suspended. In some cases, maybe there's some letter that was supposed to have been sent to you that you didn't receive to actually notify you about the suspension. And if the Commonwealth can't prove that you actually knew about your driver's license being suspended, then you should not be guilty of driving on suspended, because the law requires that you know about it, or at least that you should have known. If the Commonwealth can prove that the letter was mailed to your address of record with the DMV, and there's no indication showing it was returned, then the judge may say, well, you should have received the letter and you should have known, unless you can swear to tell the truth and swear that you had no clue and never received the letter, for example. Another defense for driving on suspended fourth offense is similar to third offense defense, where we want to look into the prior offenses. We want to look at the convictions to see if maybe there's something that's not done properly with the prior paperwork. If the Commonwealth can't prove, for example, that you had an attorney and you did receive jail time. So if you received jail time, either active or suspended, and you did not have an attorney for that case, or didn't knowingly waive your right to an attorney, then that case should not be able to be used against you. So these are some of the defenses and issues that you may be facing for driving on suspended fourth offense in Virginia. If you're charged with this offense, you should definitely give my office a call. If you have a case in my area, I'd be happy to talk with you and give you a free consultation. And if you have a case outside the area I serve, we would be more than happy to try to connect you with a local attorney who can definitely talk with you and hopefully handle the case with you. Take care. I hope you enjoyed the video. If you want to ask a question, click above me. If you want to watch another video, click over here to my side. And if you'd like to subscribe to my channel, click up here in the other corner. Have a great day.